size the respondents had for them because omunim se no kretrodo no moka and omunim se omutim fita edu ye maame so metena adaka mu a ye maame se adaka ne pa de ontena mu na entena mu kina wasesa na adwen on ma adaka ni mu na dance krata no ono an de ba ye se de akura se maka menwe yenti no ye mfa na de ma no mfa nkofie oni adanse e adan na wo mpese wo ba be di adanse na ya toto wano na ya bisa wonsem because in 2012 Owura Farijan eba court to defend the constitutional obligations and to show say abatwa sambre no ka say John Mahama we no na wa we ni ampa answered all questions enti wonya boni bia why wadwuma kama adenti ena akonta mredru udwane na eno ho asem ne yababeka muhu say ye insist through our lawyer say court no enhye maame no na ometena daka no because ono ankasa obi amfa tu ansi ni tuso ono ankasa ene ka kire court ne say omommo saa ye interrogatories ne saa ye nsem bisa no ntontwene because obetena daka ni mu a saa nsem bisa ni nyire betime bisa no. And so having intimated that to the court no on to me sanso nsesa na adwen ka say ene de memmabiem na de lawyer kra ka won say sebi onye dansi ni bia keke. Jim Mensah is not an ordinary witness in an ordinary case involving private interest. Or yet the constitutionally mandated person ono na batwa ye nyina na esi ni na so obobo results na bibia woni tim enti echinyagi a aba figures wunyina no ono pe na obetumi eyi ano na busianfo ebia na munim de enti Jim Mensah on person be wura daka ni mu no na mo meyan kan kire mo de enti Jim Mensah person be wura daka ni mu ne se onim se na komam declaration na wa ye ya court ne say or hwehwema hwese per that declaration and the figures in the declaration, you know, or mampenya kufuado nya more than 50%, no. Jim Mensah nimse won't mean justify. Jim Mensah nimse na some wa kan radio so ni in the media. Say wa ye correction of the mistake, you know, enya no kore obetena daka ni mu a ye bepa na wontoma, she will be exposed. Because the ever changing figures ahodo nsia no ebegu nanimu ase. Ama Ghana fo nyina hu se onya no kwafo. E BMG Mensah nimse from 13 now, or the IN exhibit 4, which is the presidential declaration form one. The lawyer say of failing on 9 December at the tare dan who baby or yeah declaration. Onimso na da kanimu a ehun sem bisa beba. Ebema na da this form no. Enye papa. She knows she'll be confronted with questions about the authenticity of that form and she cannot justify the authenticity of same. And until na wo dwana no. And ultimately, the Ebinumo can say, oh, NDC for another Mahama intimi case, that is why Jim Mensah says, oh, your case I had about court only a simple. Why a declaration? Per why declaration? Or Mampenya Kufuadu more than 50%. One casa why you to Musa Wayan Fonso. But Yakasa nay, with declaration why you naya bako pet. And such a why and mubi anywhere. There is only one declaration, and it is that 40 declaration that has been enacted into CI 135 and has been gazetted. And some funsoni nyinano Jim Mensah nankasa jiatum. Omo corrections almost o mayeni nyinano anadwo manasem because figures ni sisi so. And even if a correction papa mpo ye declare ye enact ye gazette. And we have presented a compelling and a solid case. MPP for him said they have a case to answer. Crocodile the John near the Roman Assembly Omusro. And you saw say the president of the bench at some point beside lawyer Kutampa say, now cry when you bra what you same way free. Oh ye Jim Mensah na easy for lawyer na. So it should let you know that because they were the beneficiaries of the unconstitutional conduct of Jim Mensah, any the easy for ayen intino. Omusro se maame no ebeba daka nim. Eya sense ba ye jayama court na court de atemu no aba yentimi anyanyansa sema misa no se na ye na ye ni maguas ai na ye de no yenya decision on ya woda na the general secretary ka ene se una o se NDC for ye ni asem bia we don't have any issue yentimi kura misa wasem papa bia because the case ni bogus ave ada na usuro that's not that kanimu na be expose how hollow our cases. This is not the time for her to run. She must account for her constitutional duties.
Michael, what's supporting the immune system? Yeah, Michael.
But what Tony?
Let's not go be able to go in the
Because supporting my boost of phone immune system. Hey, what's a Michael t-shirt? My t-shirt. The combat the fun kind of your t-shirt will go, mommy.
Boss, champion, Mr. Willie one.
Okay.
Michael, supporting the immune system.
And your well-being.
Vico 20 is not suitable for children under 12 years of age, pregnant women, and lactating mothers. A quality product from Joy Herbal Center. This advertisement has been vetted and approved by the FDA.
Proceedings of the Supreme Court. Indeed, the trajectory of this case leans credence to our position that this petition, as it stands now, does not meet the threshold of Article 64. Indeed, our position today has affirmed this assertion. It is a tried principle of law that there is the right to be heard, but inherent in this right is the right not to speak. The petitioner exercised their right to be heard, and they spoke. We have decided, as the second respondent, not to exercise this right. And in actual fact, a petitioner who has confidence, full confidence in his case, should be happy, probably popping some champagne or drinking some tea, because we have decided not to adduce any evidence. However, it is curious that the petitioner, on whom the burden of proof lies, wants the Electoral Commissioner to mount the witness box in order for him to use the Electoral Commissioner to prove its case. This is not heard of, and our application today was firmly grounded in law. Lawyers, when we go to court, decide the strategy we want to take. We, as counsel for the second respondent, decided to take this course of action. And we indeed feel that this is the master stroke and has, should I say, has disturbed the camp of the petitioner. And that is why they have made lengthy submissions as to why this should not hold. The court, we are in the bosom of the court, and we know that tomorrow the court will adjudge in our favor. We are hopeful that the court will rule in our favor. Let me land with a quote from Shakespeare in my favorite book, Hamlet, which says, "To thine own self be true, and it must follow as the night and the day. Thou canst not then be false to man." The truth is only one, and the truth is that His Excellency Nana Addo Dankwa Akufo-Addo was validly elected the President of the Republic. That is why they have made lengthy submissions as to why this should not hold. The court, we are in the bosom of the court, and we know that tomorrow the court will adjudge in our favor. We are hopeful that the court will rule in our favor. Let me land with a quote from Shakespeare in my favorite book, Hamlet, which says, "To thine own self be true, and it must follow as the night and the day. Thou canst not then be false to man." The truth is only one, and the truth is that His Excellency Nana Addo Dankwa Akufo-Addo was validly elected the President of the Republic. The petitioner has not met the threshold that has brought us to court. Yes, there is a court of public opinion, but this is a court of law. And the reason why we are here is to challenge the validity of the election. It is to determine the 5 issues that have been set down for trial. And as long as these 5 issues have not been duly satisfied, we believe that the evidence that has been adduced does not in any way prejudice our case. So we have decided that as part of our strategy, and we bear the risk, we are ready not to call evidence. And I think that should be something that we should be allowed to do. In the court of public opinion, what it is that the petitioner himself did not testify. That is something we should all ask. Why is it that John Dramani Mahama did not testify in the matter? He is the one who has brought the matter to court. He is the one who, above all and beyond, is personally affected by the matter. So he should have brought the matter to court. When we speak about this court of public opinion, there are other avenues for redress. The Right to Information Act has been duly passed, and it was passed under the watch of His Excellency Nana Addo Dankwa Akufo-Addo. The rights under this act can be invoked. Parliament, the petitioner or any upstanding citizen who wants to ensure that the EC is held accountable, as has been bandied around in court when we are not here to challenge the validity of the election, can make formal applications in that regard. So we need to focus on the issues, the 5 issues that have been set down for trial by the court, and know that we are here because there has been a challenge to the validity of the election, and that is what is important. Per Article 63(3), the person who is elected as president, has to cross a 50%, more than 50% threshold. And that is why we are in court. It is not about laying to rest certain allegations that are unfounded. That is not why we are in court.
Just a minor follow-up. Will it hurt your case in any way should the EC chairperson come and speak and confirm what you believe is what actually happened, knowing very well that the people of Ghana have not heard from her, particularly related to how those mistakes which she has admitted to were occasioned?
As I've said already, it is not about whether it will hurt our case or not. We are poised. In any way, if the court decides that we should give evidence, we will give evidence. But as I said, 1, each lawyer has their strategy for their case. 2, and more importantly, we are here to challenge the validity of an election. You, the petitioner, cannot use the evidence of the Electoral Commission to prove your case. No, that is not how it works.
I admit that indeed the proof is on the petitioner in the ongoing matters. But watching from what happened in court today, that your side also opposed that the Electoral Commission, chairperson of the Electoral Commission, who was returning officer for the poll, should mount the witness box and testify. Are you not interested, like the rest of us Ghanaians who are, in knowing what really transpired on the 9th of December, the night of the declaration in question? And also, would it not be more of a validation through the courts that indeed the president was validly elected and validly declared as such? On the matter of whether or not the petitioner has met the legal threshold in terms of proof, is that not left to the court to determine? I mean, in a number of press interactions for a number of days now, your side has always said that the petitioner has not delivered on that. Is it that determination reserved for the court, or it is reserved for your side to share?
The final determination is reserved for the court, but as a lawyer, you assess the case and you decide the strategy to take. In our estimation, the standard which we expected to be met has not been met. And as such, we think that we pray the court to use the already existing evidence to ensure that it arrives at a final determination of the 5 issues that have been set down for trial. With your second question, I hope I remember. I think it's your first question. The electoral commissioner, I keep on saying, this electoral commissioner is very tech savvy. All the results, all the documents have been uploaded onto its website. This is an electoral commission that even has social media handles. It is in line with the transparency and the need for Ghanaians to know that this information has been put on these websites. So anyone who wants to know what actually happened just needs to visit their website, visit their Facebook page or any other social media handle. The documents are there. And more importantly, the petitioner himself, through his witnesses, has admitted that he has all the documents. So there is no issue as to know what actually happened, because we all know what actually happened. And the documents to support same are available on the internet. And then when you come to the validation, as I said, the court is not here to validate who won the election. The petitioner has brought a petition challenging the validity. So if you are challenging the validity, then you need to show the court why this validity does not exist, or this validity is not what it is. So that is the burden of proof that is on the petitioner. And the court is not to validate what actually happened. So it's going into the actual issues, and that is what we are in court for. So let's always remember why we are in court. It's not about the public opinion, but for legal issues to be determined. Okay. So now I'll hand over to my sister Fati to give the tree translation.
Ghana and Central for any addition or Majibra or Moshe and Wofie. Mijidi say na eye and sama a war election petition moi a former President John Dramani Mahama or the Abedan court no be a diso. Nanso so ansa na meko ni nesi wo court dem ho na me kan mo say eye petitioner no any Ghana for do na local and international observers ka ho Moon Central for cry enam mofidi akese bebre so edi abofo mo call enkro bebre so ko hwe sa collation na ekoso at the constituency level polling station region and national edi ho adanse epefe say ye de ye nim pefe say President Nana Danko Akufo-Addo aba ye koto on 7 December 2020 no odinkunim prekope sabi former President John Dramani Mahama ena want ne ho ase ntini abepie mu o court ha na sabi nsama e ka no court ha na ayaye yi no enyina so ne adanse enya abosremuka na sa obekan a ene da tosu dumiensa a court na sinkonwa wa ha na petitioner na nkasa or say ne bonyo election na ye koto on 7 December ni echire enkenkan mu petitioner no out of 13 times a court na sinkonwa no we pie mu a ha say premier nu pe na nya no nko a o petitioner no kra na eye court hansama ekoso esunsun sanso onim se ebeka na se ne se bi NDC ni bi a wotu ne na abesi ha no ono ankasa kra wanyi ne ho danse ni amfa na danse ama medan court no samo bekan a eye nra petitioner na lawyer for say ensama omode beda court enyina so enimu adanse enyina omode abegu ewo mu say ansa na court no be start esi nkonwa no na omo ankasa yi court na suture se nyame adoma adanse fo num e na omo be frɛ omo form asemu megu nra na adanse fo miensa e na omo frɛ eye owura se edu nketia eye Dr. Michael Pesa White ene owura Rojo Metal Nunu ene adanse fo pa omo frɛ say ye ka say ye nsori ntia mu say kian ne kin esese adanse fo mienu omu yi court suture se omo be frɛ omo no omo nkofo omo mra atokos da bi ye nka asa efi se court ha say na ayaba no ye de emra ene ye adwuma enti sa mra na ema petitioner no kwan se ma ne megina adaka mu medi adanse emfa moa ne case no sa mra na nso so na ma electoral commission chairperson so akwanya se won pese obegina adaka mu abedi adanse de abeboa ne case a ehun hia se obegina adaka mu enti na ye gina ha no na sa obekan so a eye petitioner no na dance for na lawyer for ensema na omo kan court dem ho no e kame aye say omo kira ade ba ko pe se ɛyɛ adansefo miensa omudo mbegyina adaka mu no ensama ombeto to papa so ne omude beda court ni nyina kame aye say antimi ama enyina so nti a adesrede omude abeda court nanim sa court no enkase ɛyɛ aba ma meji mensa o declare ye no eni emra no boy bra anase ɛyɛ aba ye koto ye no obi ani nkunim enti court no nhye na yensa anye nhyehyɛ foforo na ɛyɛ former president John Dramani Mahama ene president Akufo-Addo omunsan kosi aka ni bio no oma dance for miensa na omu begina adaka mu ebe so aye so omu ka nokre no omu mu bia ni hono ma otimi ma adanse a etimi pagya omu koduru mpempenso a court no ebetu no ho asi wo se saa de srede omu de abedan court omu de be mo omu enu nti omu se saa de a ene esese ekọ hayo esese ye hye EC chairperson ne keten se wo pe wo megina adaka mu ni antoto na no na ehe na wote sesa wo sama obi a nipa na wasama no ono ne sai na so die so obeyi wadanse enya wo wadanse ni nyina so na sesa wo de be dan court no ebio ene obetie lawyer penina na okasama petitioner na ose ai enam se ebra omode adesrede beto court batan yanim senke yam o makwanya no mo ntoto electoral commission na no enye nsemfo abi asa akwanya na ama no na ekire se ne ye nhye se EC ba panyin begina adakam na nya sa na court ne kan court no a ruling omode ba ye on that issue of interrogatories no omo say efri say eye ensama na petitioner na lawyer for atwere guru akrata so any set of questions omode be dan court no in interrogatories na ehun hia eye irrelevant enti na court no bogu ye court na antwere wo ruling no mu say enam se na ma me na twere e wo affidavit mu so onya akwanya say obegina adaka mu obeyi nsem na no nti ma na nya nti san nsem na omo keka wo ha se ni nyina emfa kwan mu ebio mehu se petitioner no ne kasa mafo ne lawyer fo ni bi begina adaka yanima omo ka kire mo se ai emse court dem ho de emra kwa mu de bia ne ani nkunim enti yemfa propaganda mbeda aga na adehye no omo nka ya se mo maye na ada wunsura adenti na amegina adaka mu accountability nti adenti na amegina adaka mu yenyina yenim se ga na adehye ya na musifo wo mrahye bedwam ase ba no nkontabuo ne accountability a sabi omutimi frɛ isi no anase isi na adwumayefo ebrebia emo bebu nkunta ekire ga na adehye through parliament emo kasa adwuma amode maaye no mpempenso a ya akoduru ni na ha na yede yekɔ ena court na ya ba begina ha no eye petitioner no anchekire yen sa begina court ha se oba for accountability also oba se declaration na isi ba panyi eye no ebu eye ga na mrapon no article 63 clause 3 nti ne ejina ha o say declaration na ma me ne ye na ebu mra because obia enya 50%